Sir Mahdev, Mohan.
Mr. Speaker, sir, despite being named the Criminal Law Temporary Provisions Act, the CLTPA has been renewed multiple times since it was first enacted as an ordinance in 1955 to deal with secret societies and gangsters, as the ministers explained, at a time when these societies were rampant in Singapore and presented a real material threat to public safety, peace, and good order. Over the years, many parliamentarians, backbenchers, opposition MPs, and NMPs have said in this House that the powers the CLTPA gives to detain a suspect without trial may nag at the conscience. Yet time and again, this House has affirmed the CLTPA as a blunt but necessary tool, a tool of final resort to battle against organized criminals in all their forms, a tool to protect law-abiding citizens who might be deterred from resorting or testifying about crimes due to the threat of reprisal. I note from the statistics that the minister showed today that the number of suspects detained under the Act has fallen from more than 300 to just 100 in the past 10 years. I support, Mr. Speaker, sir, the hard choice that has ultimately and always been made over the past few years and multiple years actually to revive the CLTPA. However, the amendment bill before us today is different in certain respects, and allow me to focus my speech just on Clause 3. At first glance, this clause has troubled me. Yes, the proposed fourth schedule of the amendment bill helpfully lists, for the first time, the activities of a criminal nature that the CLTPA covers. But Clause 3 makes final the minister's decision as to whether a person has associated with the CLTPA's criminal activities, whether it is necessary for a person to be subject to police supervision, and importantly, whether it's necessary for a person to be detained. I was originally concerned for two broad reasons. First, the amendment proposed in Clause 3 could effectively liken the CLTPA Section 30 with Section 8B2 of the Internal Security Acts. The Internal Security Act 8B2 expressly ousts judicial review in any court of any act done or decision made by the minister. Judicial review, Mr. Speaker, sir, is an important check on a minister's administrative power in the CLTPA and legislation as a whole, and it's confined at common law to reviewing the illegality, procedural impropriety, or irrationality of a decision-making process, ministerial or otherwise. It is thus reassuring that today the minister has said that this judicial review will continue to be available. Without the court's review, there is fear that investigations or investigators, however skilled they may be, may make errors, that they might prefer to proceed under the CLTPA where there is insufficient evidence to sustain charges under a host of other statutes. And Mr. Speaker, sir, I must say there are many. There is the Organized Crime Act of 2015, the Misuse of Drugs Act, the Remote Gambling Act, the Common Gaming Houses Act, the Corruption, Drug Trafficking, and Other Serious Crimes Confiscation Act, the Terrorism Suppression of Financing Act, just to name a few. And of course, there's the Penal Code. All this legislation, read together with the CPC, the Criminal Procedure Code, allows for judicial supervision and due process, the hallmarks of the administration of criminal justice in Singapore. Therefore, there was my concern that the judicial review process would have been removed from the CLTPA by this clause. Mr. Speaker, sir, safeguards must always be put in place to ensure that the investigative powers are not misused and to weed out mistakes that can happen from time to time. It cannot be said, Mr. Speaker, sir, that the CLTPA's Criminal Law Advisory Committee can serve as a check on investigators or the minister's powers. After all, this particular body performs only an advisory function and has no decision-making powers of its own under the CLTPA. I appreciate, Mr. Speaker, that the minister has clarified that as of March this year, there will be a sitting judge who sits as a chair of this advisory body. But can I ask, for the purposes of clarification, whether the constitution of this committee and the purpose of this committee would change? Will it be transformed into a decision-making body? I do not suppose so. Could I have that clarification? Nor should, of course, the onerous task of being a check on investigators fall on the president who confirms detention orders under Section 31 of the CLTPA. In these circumstances, what obligations can we expect to be imposed in due course on the criminal law police supervisees through subsidiary legislation? Second, Mr. Speaker, sir, I was deeply concerned at first glance that history was repeating itself when I first read the amendment bill. I was reminded of the Court of Appeal's decision in 1988 in Cheng Swan Zi against public prosecutor, where a case was legislatively overruled. I asked myself, why should we wind the clock back 20 years to 1988? Why reverse the courts when the minister just yesterday so convincingly reminded us of the need to trust the court's wisdom, regardless of whether we agree with the decision? Again, I am reassured this morning, today, that this is not the case. That the purpose of this bill, this amendment bill, is not to parliamentarily override the case of Dantan, an apex court decision. But if this is the case, may I just ask the minister, Mr. Speaker, sir, as to why we are having the finality clause, or the words final, being included now, after all these years, within this statute. If it is not to reverse Dantan or other similar cases, why should we do so now? If the decision, as we know from the Court of Appeal case in Dantan, has always been for the minister to decide, is it necessary to ensure that that decision is final in statute, having the words, it is final? Why now, and why do we have this? The apex court's reasoning in Dantan at paragraph 74 bears mention, Mr. Speaker. And let me just read out the most important sentences. The apex court, or the Court of Appeal, said, in this case at paragraph 74, that the CLTPA vests a potentially draconian power in the executive. Public safety, peace, and good order can cover a wide spectrum of possible scenarios. It is true that Parliament has vested this power in the minister, but the court is to closely scrutinize the grounds put forward by the minister and consider objectively whether on the face of these grounds the decision is open to challenge on the basis of illegality, irrationality, and procedural impropriety. In the face of what the apex court describes as a potentially draconian power, I fear, and I would like some reassurance as to whether the proposed amendments may ultimately have the effect of limiting the scope of the judicial check on the executive. On the off chance, as an example, on the off chance, if someone were to challenge a detention order in court, would the court's role be confined to verifying, almost as a clerical matter, that the paperwork is in order, that it includes a bare recitation by or on behalf of the minister that his decision is such and therefore is final, and that he acts with the public prosecutor's consent? The apex court in Dantan flatly rejected such a narrow rule and held that a court may and indeed should examine whether the power vested in the minister is being properly invoked. I ask, how will the public, Mr. Speaker, sir, be assured that the grounds for detention without trial or continuous police supervision in a particular case is not procedurally improper, illegal, and/or irrational? Given the Court of Appeal's reasoning, may I make one simple and humble recommendation? In addition to having, as we do now, as I've learned just today, that there will be a sitting judge who chairs this advisory committees, may I suggest humbly that the written statement of the grounds for detention or police supervision that is made under the CLTPA Section 31 and that is shown to the advisory committee be also made available to a judicial review court if the case so arises. I ask for this because I know that even in the case of Dan Tan, this particular written notice was not made available to the Court of Appeal. Finally, let me end, Mr. Speaker, sir, with a word. Let me say that we should think on the fact that there will be others who occupy the august office of the minister. The minister, as he reminded us even yesterday, is in a unique and special position, having been for many years a senior counsel and then a public servant. Should we be mindful of future ministers of law who may not have the same set of skills, who may not have had the benefit of doing criminal defense litigation work or even representing people who've been detained without trial? So looking forward, if there could be put any safeguards which limit this, that'd be perfect. Thank you, Mr. Speaker.